Hi Thomas, if you have a moment, I just want to flag a few concerns I have about that advice we discussed yesterday. I'm of the option that it might be worth a further meeting with Mitchell before I send out a written advice. Firstly, it looks like they are carrying on a business in partnership. Section 5.1 of the Partnership Act states that partnership is the relation which exists between persons carrying on a business in common with a view of profit. The element of carrying on a business is defined in UDC versus Bryan as a commercial enterprise, and the nature of the commerce itself as a profit venture and as a business organization. The brothers have more than a sharing of gross proceeds, which takes place with many rentals and bail agreements, such as for tenant farming or chairs in barbershops or taxi driving. In this case, it appears that the parties intend to share profits. Now, registering a company and transferring the business might help them, but as I plan to point out in my conference with them, it is fairly costly in terms of the small size of their operation and because of their small turnover. Also, because of the duties required of directors set out in the National Safety Council case, essentially because the community has come to expect more from company directors who deal with other people's money. Parliaments and the courts have found it necessary to refer to the demands made on directors in more exacting terms than formerly, and the standard of capability required of them has correspondingly increased. So, a director who is not capable of understanding his company's affairs to the extent of actually reaching a reasonably informed option of its financial capacity is personally liable for its debts if it becomes insolvent, and the test is an objective test. Company constitutions are given contractual force by Section 140 of the Corporations Act, which provides that they have the effect of a contract between the company and each member, and in that light are not much different from a partnership deal. The fact that a company has separate legal personality and a partnership does have very little practical effect for this reason. Seen in the light, the director of a small proprietary company faced with the need for personal guarantees and the prospect of directors' penalty notices, as well as matters I didn't mention to the client, such as personal liability under legislation ranging from consumer matters to work cover, is in practically no better situation than a partner, and is actually behind because of the extra compliance obligations. A breach of these obligations can land a director in jail under Section 588G3 to 3B of the Corporations Act, where the director has acted dishonestly, but a careful reading of the section shows that is in wider in scope than the definition of theft under the Queensland Criminal Code. Partners, when acting in the course of the partnership business, are agents not only of the partnership, but of each and every other partner. This follows the provisions of Section 14.1a, known as the Doctrine of Observability Authority, as seen in Duke Group's case. A director can bind the company under the same doctrine, unless limited expressly. The implied authority of a director will extend to all those that act are customary exercised by someone of that position. So where a director does something which might be considered reasonably necessary to the business in the usual way it is conducted, the company will be bound in the same way that a partnership is. Again, no practical advantage in a company structure. It's arguable that in a company with several directors, a director acting individually has no usual authority to bind a company and has the function merely to participate in the process of making decisions, rather than making them himself. That's only the case in companies where single directors can't act by themselves without a resolution of the board. It used to be the power of a company could be restricted and practically in Section 124 and 125. Do this either by allowing objective clauses in the company's constitution or express prohibitions on the exercise of power in constitutions. But for small proprietary companies, these clauses are optional, and where a company acts contrary to them, there is no effect of invalidity. Therefore, the ultra-virus doctrine is effectively abolished. If that transaction causes the company's insolvency, all directors then become liable, depending on their possible defences to a Section 588 claim. If a partner enters into agreement which is within the scope of the usual business of the kind carried out by the firm, it binds the firm and other partners even if the agreement has not been authorised by the partners. Section 13 of the Partnership Act is transparent in that all partners are equally liable for any partner acting within the authority of co-partners. In common law, this includes civil liability in tort. If the partnership assets are insignificant to pay all of the partnership debts, each partner is liable not just for their individual debts, but also for all partnership's debts to the full extent of his or her personal assets. The creditors of a partnership has the choice to sue the partnership, or in the present case, either of the partners. It is slightly harder for creditors to sue the directors, and generally, but not exclusively, this task falls to the liquidator. The liability even extends to those who hold themselves out to be partners, just like shadow directors. So if the cousin is represented as a partner, by words or by conduct, she incurs all liability of an actual partner with respect to outsiders acting on that representation. The partnership will need a separate ABN, and this does not make it a legal entity, separate from those from its constitutional partners. One final thing which is hard to suggest tactfully to the brothers is that if there is a dispute, each of them has its obligations to accompany which they are or have not only been directors, but even employees in some circumstances, to expect that they will act in the company's interests, even if the company is in liquidation, to the exclusion of any other interest. That means if a company is being sold to a competitor, a sworn enemy, they still can't compete with it. Something unlikely to happen if the partnership becomes insolvent, because the relationship between the parties and their business contacts is personal and not a relationship. What are your thoughts on that?